about ongoing criminal trials means that there's going to have to come a point where courts confront the reality that jurors may well be biased based on what politicians are saying. There has to be some kind of method of preventing people from talking about ongoing criminal trials, because the whole basis of the justice system is that people get a fair trial with an unbiased jury. And if they see the President of the United States calling a 17-year-old kid a white supremacist, that's a real problem. And that's also one of the things that the judge in the Chauvin trial said. Talking about Maxine Waters, I can't remember what she said, but I don't know, like we should string them up or burn the town down, something like that. So that's a problem that didn't used to be a problem. It kind of goes into what we were talking about last night with defamation. I mean, typically speaking, the media can say anything about anyone because they have a very privileged position as kind of supposedly the guarantor of the First Amendment, getting information disseminated to the population so that we can make decisions. But if the media is extraordinarily biased and is saying terrible things about people constantly, then we have to revisit that, and the courts will have to revisit that. And also the question about calling someone a white supremacist. It's, I don't know, 30 years ago it might not have been that big a deal. Somebody could have sort of shrugged it off and it wouldn't have impacted their life. But now if somebody calls you a white nationalist or a racist or whatever, and there's enough of a pile on, which social media enables, you can lose your job, you can be put in a situation where you can't feed your family, or you could lose your home, your apartment, or whatever it happens to be. And that then makes the epithet sort of similar to calling someone a murderer or a child molester. And those, if you call someone something like that, and it's not true, then you have committed what's called defamation per se, and that person can sue you for money damages even if they didn't suffer any damage. Like if you call somebody a child molester and they're not, and you knew that they weren't, or you didn't have any good basis to say it one way or the other, they can sue you for a lot of money even if their life didn't change for that. And I think we're heading towards a situation where conservatives are going to have to sort of get legal defense funds together that start aggressively prosecuting defamation suits based upon inappropriate claims of racism, because it's being thrown around so much now and it doesn't even have any meaning anymore, and it's really hurting people. So long-winded, but that's your answer.
Speaking of the jury pool, do you get the feeling at all that, or do you have any thoughts on whether or not the defense kind of dropped the ball in jury selection at all? I just listened to Robert Barnes sharply criticizing the defense, or Richard specifically, for not probing the jury at all, not hired any other outside consultant or attorney to look into it, not alerting this old boomer judge, though I do think I like him, to all the potential media bias. And now it seems like it could really be coming back to haunt them.
We touched on this a little bit last night. I mean, I know I don't know Robert Barnes personally, obviously. I'm vaguely familiar with his work. I know he's been a really good trial lawyer. I know that he has a podcast or something like this, and he talks about this stuff. And I also know, because I watched about 15 or 20 minutes of a video he did with someone where he was talking about his role in this trial and how I guess he was sort of pushed out. I have obviously no idea what the background of that was. But what I heard him saying was that he had assembled a series of experts who could, read body language on jurors and that kind of stuff. I mean, every lawyer's going to tell you a different story about the value of something like that. The consultants themselves are going to claim that they can read everyone and that they know everything. I've worked with jury consultants a few times, and to be honest with you, the decisions that they made very rarely contradicted my own gut instinct. So they were sort of there. By the way, do you know who these people are? They're usually sort of failed academics, kind of like economic experts in a commercial trial. They're like psychology PhDs who, for whatever reason, couldn't get a university post, and they wind up being legal consultants for stuff like this, and they sell their expertise and their credentials as if they can read everyone, kind of like those body language experts that Bill O'Reilly used to have on his show. So I don't. If you're a smart person and you have a good sense of people, I don't know that it's necessary to hire people like that. And again, these guys who have conducted the defense of Rittenhouse, so far as I can tell, have done a pretty good job. And they're from the area, and they probably have a better read on the people there than Barnes does, or any of the people that Barnes might have hired. Well, at the end of the day, that's just my opinion, speculation. It could be that Barnes is totally right, so I'm not criticizing him at all. I'm just saying that a relatively small town lawyer who doesn't want to deal with a lot of experts from Los Angeles and New York who pretend to know everything about people in places they've never visited, it's hard for me to criticize what the defense did.
Hey Fisher, I have a quick question. Assuming that Rittenhouse is eventually acquitted by the jury, I'm wondering, would that preclude the families of the people he killed from bringing a civil lawsuit? Because, the whole claim is self-defense. So would that prevent them from recovering damages civilly?
No, it would not. The civil lawsuit and the criminal lawsuit are completely separate. And no matter if first of all, we probably won't, if he's acquitted, we won't know exactly why. We'll just know that he's acquitted. But even if the jury said explicitly, we think that, he acted in self-defense, no, they could still sue him. It might, and technically speaking, the result of a criminal trial is not evidence in a civil trial. So that would be a whole separate proceeding. But, um, I mean, the reality is it's unusual for somebody to be acquitted in a criminal trial and then held liable in a civil trial. The glaring exception, of course, is O.J. Simpson, but that was a really extreme case.
Yeah, and then I'll ask another question on the issue of defamation. At this point, he's obviously extremely famous. So my understanding is that like public figures, there's like a higher standard they have to show to collect for defamation. So would he fall into that category? Due to all the attention this case has garnered, or is he still considered an ordinary person for
He's
defamation
still
purposes?
considered an ordinary person because he's not a public figure because he went out and did anything. He's a public figure because of the attention that's been given to him, really through no fault of his own. A public figure is somebody like the President of the United States, or a media figure, or a sports athlete. Tiger Woods is a public figure. Bill Clinton is a public figure. Kyle Rittenhouse is a 17-year-old kid who we would never know anything about if this hadn't happened. So no, that wouldn't be an issue. If people, I got a little bit of a backlog of people who want to talk. So if you have already spoken and you don't want to, you're all done. If you could leave as a speaker, that'd be useful. Then I could bring on people who do want to say something. Thank you.
Hey, Fisher, given that we're headed towards day 3 of deliberations, what do you think the likelihood of some sort of compromise verdict is, and what do you think a compromise verdict would look like at this point?
Well, somebody's going to have to remind me of the. I only vaguely kept up with all the charges that are still in there. So I know the gun charge is gone. He's obviously being charged with, I think, murder too. And then I think the second charge is basically a kind of a reckless homicide. Can anybody confirm or deny that for me? I think that's what it is. Well, let's just assume I'm right. I mean, with these so-called compromise verdicts come down to is a debate in the jury room about the level of intent, the mental state of the person when he did the killing. So what's interesting here is that Rittenhouse admitted on the stand that he shot these people on purpose. So there's not an issue about his mental state. He said he did it intentionally. So his defense is not that it was an accident or any of that kind of stuff. His defense is that he had a right to do it because people were attacking him. Okay. And I think that there's another charge, which is something along some kind of recklessness or something that, there was a point in time where, he could have made a different decision and therefore it's reckless what he did. I think that's what's at stake. And I think I said this last night, but I don't really see a compromise between this. And there was a debate at one point about jury instructions and getting certain charges thrown out, which was that if he goes on the stand and openly says, "I did this on purpose," then how do you charge the guy with a reckless kind of a homicide? And if memory serves, there was some kind of fairly convoluted argument on the prosecution's part that allowed them to keep that charge in the case. So I think that that's true. If somebody knows something I don't know, they can correct me. But I think that's what it was. The general matter on, I said this last night, I'll say it again. I'm sorry if everybody heard this already and I'm repeating myself. Typically, when there's a so-called kind of compromise verdict in a jury room, you're dealing with, let's say somebody's been charged with um, second-degree murder and manslaughter. And the difference between those cases, the elements are basically the same except for the mental state of the person. Did he do it on purpose, maliciously, or did he do it in a fit of rage, or did he do it accidentally but it was reckless? Like, for instance, if I take a rifle and I try to shoot one person, I'm trying to kill that person, but I don't hit him, but I hit someone else. Well, I'm not going to get hit with intentional murder for that because I didn't intend to kill that guy. But I did something that was intentional and that was reckless that did result in death. So I'm going to be held liable just on a lesser charge, as ridiculous as that sounds. These are the kinds of situations where a jury will sit down and say, well, we know he did it, we think he was wrong, but we don't want to hold him as responsible as if he had planned it out methodically like a serial killer. We're going to hold him responsible as someone who did something he shouldn't have done a little bit reflexively. And I don't really see that here. So I don't know. I mean, my suspicion is he's either going to be found guilty or be acquitted. On the other hand, I said this last night too, the jury has instructions and they have technically legal rules that they're supposed to follow. But when they're in that jury room, they can do whatever they want. They don't actually have to follow those instructions, and they don't have to give any account of how they arrived at their conclusions. All they have to do is fill out a verdict form that has certain boxes they have to check, and they can come to an agreement that they think someone is guilty, but they're not going to, hold them accountable and check not guilty, or they can say, we don't think this guy is culpable, but we don't like him and we want him to go to jail and find him guilty. And nobody can ever challenge what they do. So that's a kind of a release valve of justice, meaning that we have a kind of a legal system and certain rules about what you can and can't do. But the jury system exists to allow citizens of our society to either convict or release people for reasons that are not related to direct guilt or innocence as a legal matter. So we don't really know what they're going to do, and we will never know how they arrived at their verdict after the verdict is given unless the jurors choose to tell us, and probably some of them will because they want to be paid for interviews or books or something like that. But in a normal case, you don't know. And I said this last night, but in a normal case, this is really abnormal because a murder trial this simple would normally last 2 or 3 days tops. The fact that it's gone on this long is just a function of the media scrutiny. Long-winded. I'll try to be a little more succinct.
Hey, so I think this whole thing, right? I think we all know what the verdict is for the most part. I think what it comes down to is Wisconsin, is it a morally red state or a blue state, right? I think what's going to happen is if it is a blue state, then the jury then will kind of lean towards that it was not self-defense, that he just went out there with a rifle and he went there with intent to kill, and that's what he did, and that's just how it was. If it's more of a red state, then it was his self-defense. That's what he did. Went out there, he got attacked, and he defended himself. Which I think mostly, if you're in the red, you believe in the Second Amendment, you believe that that's what happened. He went out there and he defended himself, right? I think mostly for my part, I think that's what he did. He went out
Yeah,
there
I'm just gonna like
for.
I got your point. I mean, that's a very cynical attitude, and you may be right about it. It may. I mean, I'm sort of cynical too. So it may well be that red state juries. It's a little more complicated because there's often red states with blue cities in them. So you might be better off in a rural town in eastern Oregon than in Austin, Texas, for instance. That's entirely possible. So it's a little more complicated than red and blue states. But, is that going to play a role? The political matter? Yeah, probably. But I mean, we'll never know that because no one will ever admit it. No, the jurors, if they come out and they tell us how they arrived at their conclusions, whether it's a conviction or an acquittal, are never going to tell you, well, I'm a Democrat or something like this. So like I've been saying repeatedly, though, that if you are a red state kind of person in a blue city, it is a fact that you're going to have a harder and harder time getting a legitimate jury to judge you. And I think that that is not really true if you're a blue person in a red state. I don't think the vindictiveness, at least not yet, is at that level. So that's all I have to say about that. All right, folks, this was just supposed to be a cleanup and a Q&A for people who wanted to ask questions that were new or that weren't covered yesterday, that didn't hear something yesterday. So I'm not going to give any speeches. So if people don't want to talk anymore, that's perfectly fine with me and we can wrap it up. I just did this because people requested that I do it. So I'll leave it open for another couple minutes if people want to speak, but otherwise we'll wrap it up. It's up to y'all.
Hey guys, I'm interested in your opinion on why the defense attorneys decided today during the conversation with the judge to file a verbal mistrial without prejudice when they had recently filed one with prejudice. What are your thoughts on that?
Well, they'd already filed one with prejudice, so they've got that on the record. And if you're going to file a motion, they could have filed it with both, okay? But they chose it without prejudice, probably because they took a look at the video and they saw that it was cloudy and it wasn't as good as what the prosecutors themselves had. But they didn't think that the distinction was so extreme that literally, basically giving someone the function equivalent of an acquittal was warranted. So I said this earlier, but I think what they were doing was making a record and making sure that every possible avenue was open for them on appeal in the event that there's a conviction. I think that a lot of the Twitter stuff I saw about this today was like kind of exaggerated and extreme. Like they thought this was a huge deal. To me, I saw it and it looked to me like business as usual. I mean, the only thing that I read into it was that maybe the defense is a little bit nervous. Other than that, I just thought that the hysterical remarks about it was just they were people who obviously have never been lawyers.
I
Hey.
got.
Sorry.
Oh, yeah. I just got one more thing, bro, and then you can go. The judge has at multiple times throughout the trial proceedings um that I've watched gone to say something and has caught himself and said something along the lines of, well, I won't get into that now, or, well, you know, maybe later I'll have to discuss this and X, Y, and Z. Do you think that gives insight into his thought process as to the case potentially going to appeals court no matter what?
No, I don't think it gives any insight into it. I think that they're waiting for a verdict and they don't know what's going to happen. And one of the things that a trial lawyer has to do, which is lost on most of the people watching a trial, is he has to make a record. Because any issue that he doesn't insert into the record is not appealable. So, for instance, let's say that there's some really critical testimony that is hearsay and the defense lawyer doesn't object to it. If he doesn't object to it, he can never bring it up ever again. So there's two things
I
going
see.
on. He's fighting for acquittal, but he's also covering his client's ass in case there's a conviction so that he has a second bite at the apple down the road. So, a lot of the stuff I saw today about the defense lawyers are, they're desperate or they think they're going to lose. That may well be true, but the people who were saying it mostly, don't understand how this works, and the hysterical reactions were, a function of their lack of understanding.
So, in your opinion, they're just doing these procedural things to get on the record to make the appeal case in the future that much stronger if it comes down to that.
Yes.
Okay, thank you.
Fisher, quick question. I'm not asking you to mind read into Schrader's, getting his head or nothing, but my question is this: if is there, my understanding is that he can give or grant, he's been sitting on this motion for mistrial with prejudice, and he could, I guess, grant it even after the jury has come out with a guilty or an acquittal, or obviously not an acquittal, excuse me, but a guilty verdict. What's the logic, I guess, or what kind of game theory may be going on him sitting and waiting? Is he trying to give the jury maybe a chance to, I guess in his mind, maybe do the right thing? Again, I'm not trying to mind read, but
A judge never
he
wants
could
to.
also, in another sense,
A judge never wants to take a case from a jury. Okay, because taking a case from the jury creates a legal decision. So if let's say that Rittenhouse is convicted, and the judge pulls out of his back pocket the motion for a mistrial with prejudice and grants it, Kyle Rittenhouse is not out of the woods, because what the judge has done is made a legal determination, and any legal determination is appealable. So if he did that, technically an appeals court could come in and say, well, we think that was the wrong decision. And if the appeals court ruled that way, what would happen immediately is the jury's ruling of a conviction would be reinstated at that moment. So what a judge wants to do is let the jury decide one way or the other. Because let's say if the jury acquits Kyle Rittenhouse, there's no appeal. It's over. That's a factual determination and a legal determination. But it's a factual determination, and factual determinations are not appealable. Only legal determinations are appealable. If the judge takes the case from the jury for any reason, that's a purely legal ruling that can be appealed. So let's say that the judge maybe has some sympathy for Rittenhouse, and a lot of people have speculated that he does. If he does, what he wants to happen is for the jury to come back with an acquittal, because that's the end of the road, and then Rittenhouse is free, at least on these particular criminal charges. So that's the inside baseball.
Okay, but getting back to like the grainy video and what I said earlier about a mistrial potentially being one of the like most incendiary things, the reason that it's just sort of to elaborate on what I was meaning there is that there's been a lot of sort of hubbub about how the judge is biased and all this stuff, and obviously that's mostly or entirely, from what I can see, media spin. But I think something like this sort of narrative about how people are now saying that the defense is looking weak, and then after all this chatter, then even if it's before a verdict comes out, if the judge then declares a mistrial, then I think people can make a lot of hay out of that and saying that the judge is doing this for, like, obviously because he cares about what the verdict is going to be, and then that could incite stuff. I don't know.
Yeah, I mean, I can't really comment on what's going to incite people because I don't really, I know Wisconsin a little bit, but I've never been to Kenosha. And, the only comment I'll make on this is that the judge seems to me to be pretty careful for the most part, pretty good guy. I've said this repeatedly. It's obvious to me that he's enjoying the limelight because some of the things that he's doing are performative for the camera, and a judge, I'm sure this judge too, wouldn't do in a normal trial that wasn't being closely followed by the news media. But I haven't seen him do anything that struck me as really wrong. So, I mean, like whether he has the courage to, you know, grant a judgment notwithstanding the verdict and acquit Kyle if he's convicted, if that's what he believes the verdict should be, because that's another thing that I didn't mention earlier, but a judge can always dismiss a jury verdict and rule as a matter of law that the facts were so one-sided that a reasonable jury could only come to one conclusion. But again, that's a legal determination which can be appealed. So that would be good for Kyle, but it wouldn't be the end of the road. He'd still be enmeshed in probably years of litigation after that. So the best outcome is a straight jury acquittal. So in terms of I don't really want to talk about what's going to incite the mob or whatever because I'm not qualified to talk about it.
I guess I have a big picture question for you. So Schrader, I believe he even made a comment today about how he may reconsider ever.
I'm just going to interject real quick. I
streamed
see people doing this,
cases.
putting the hand up thing. I don't really, I don't really pay attention to that. So if you want to talk, just kind of butt in. I'm a New Yorker type, and I'm used to just going up to the lunch counter and not waiting in line. Okay, go ahead.
Roger that.
You think it's a net positive overall to live stream just about every case? Like, I'm sure this is the most enthused audience you've had in a while, but I think it's exposed a light mostly on what goes on inside of these,
I think
cases.
in normal circumstances, live streaming a case is a terrible idea. I think that it turns everyone into a potential celebrity and that they behave differently in front of a camera than they would if there were no cameras present. It's one thing to have a newspaper reporter and to know that the newspaper reporter is going to write down what you say and print it. It's another thing to realize that you are literally, essentially, your own Tom Cruise for 10 or 15 minutes or whatever it is. So under normal circumstances, it's a very bad idea. It's detrimental to justice. In a case like this, my opinion is different because this is a consequential case that matters to a lot of people, and for everyone to sort of have a kind of a trust in the process and the outcome, giving them the ability to see it is important. But in your run-of-the-mill case, no, terrible idea to have cameras in the courtroom.
Hey,
Fisher.
Fisher,
Thanks for
real quick.
I'm
putting
going to do
this
the
on. I
comb
greatly
book. Hold on a
appreciate.
second. The other guy was first. Let him go, okay?
Thank you. Just my question is, do you think there's any or what do you think is the significance of the request for the drone footage? Because my understanding is that when I was watching the original debacle a few days ago about the drone footage and the quality of it, it seemed like the main thing that the prosecution was trying to get out of it was show that the gun was raised prior to Rosenbaum being killed. And so I'm wondering if, like, my intuition was like, okay, if the jury is requesting this, it seems like that they're thinking that's a salient thing for them to make their determination. So I'm curious what you make of that, Fisher.
I don't know. I mean, I'm not in the jury room, but I'll tell you, the thing about juries is that it's not unusual to have one or two borderline autistic people who find their way onto the jury who focus on something like whether the gun is raised or not raised. For me, as a common sense human being, that's not a very salient point. And I said this before, but hey, the guy who's A, can you turn off your speaker, please? Thank you. Um, uh, the reality is that most people make their minds up at the beginning of a trial, and then it's very hard to change their mind. There's a lot of things that can happen. They could change their mind, so it's not like it's a lost cause. But the reality is, after opening statements, people mostly have a good idea of what they're going to do. And when people make decisions about whether something was a murder or whether something was self-defense, they mostly don't think about things like when exactly, at what split second did he raise the gun. But we all know that there's autistics, and some of us have run into them on Twitter, who do think about these things. So, I mean, I don't know. Like, I could speculate. Once,
If you're running at someone with an
no. I don't
AR-15,
allow people to interrupt when I'm talking. Okay, so I'll remove you if you do that again. Okay. Mute yourself.
you
No.
said intervene. You said the button. You said when you
All
were.
right. Okay. So anyway, yeah, you can butt in when I'm not talking. All right. So you ask me a question, I'm going to answer the question. The reality is, people make decisions based on their gut instinct, and whether someone is coming at them in this way or that way, they're going to make the decision based upon their overall kind of assessment of the circumstances, is my opinion. I don't think I have anything more to say on that.
Thanks.
Hey, Fisher. Thanks
What
for
do you
putting
think
this
is
on.
the
Excuse me,
correlation
Shepard.
between this case and the Getz case in New York in the 80s? And do you see a rise in, will this case be passed for vigilantism in the future if he's acquitted? What are your thoughts on vigilantism in this case and the similarities to the Getz case?
Well, I'm going to assume the good faith of your question. I don't see any similarities whatsoever between this case and the Getz case. For the people who are on here who maybe don't know what the Getz case is, in New York City in the 1980s, it was basically a massive crime zone, a hellhole. Some of us remember this. And people got robbed left and right. People got robbed in the subways. They didn't want to ride the subways. And things got so bad that guys started buying kind of Saturday night special pistols to protect themselves. Bernie Getz was a little guy, little white guy, little white German guy. I think he was probably maybe what people around here call a manlet, maybe 5'5", 5'6", something like this. He'd been robbed a couple times, and he went on the subway with a gun, and 4 dudes approached him, and they were going to rob him. It's very obvious, and he shot him. And I can't remember if any of them were actually killed. Some of them might have been killed, but definitely they were very, very badly wounded. One guy was paralyzed. And then he kind of went on the run. Now, those of you who know New York, this didn't happen in like Flatbush, Brooklyn, or the Bronx. This was in Greenwich Village. He was on the Red Line in West Village where this happened, which is a super safe area, at least until recently. So this was it was considered to be vigilantism. He was then tried for, the possession of the firearm and then also for shooting these guys, but he was acquitted. The jury refused to convict him, and the interpretation of this was that we're not going to convict a guy in a situation like this where he's protecting himself because the crime is so out of control. You got to do something. This is a little different because this was just kind of like a riot in a very quiet, peaceful town where people were going and looting and burning things down. In other words, it was a nice place that people were going to protect. It wasn't like a terrible crime zone where a guy felt cornered and he had to get a gun. So if that answers your question, I don't approve of vigilantism either, and I don't regard what happened here as vigilante at all.
Yes,
Hey,
the
Fisher,
question was
I was
answered.
curious.
Thank you
Dude, you
very
just
much
went.
for answering it.
Yeah, you're welcome. Yeah.
Thanks, Fisher, for putting this on. I had a question for you about the, I guess, the disclosure of the video and it sounded like that the prosecution recorded a separate version and gave it to him after the fact. Assuming that they go through the metadata and they found some sort of malfeasance within that, does the prosecutor face any criminal sanctions, or is it just like work-related stuff that he faces if he's found to have committed wrongdoing?
If he doctored evidence in a way that makes it look that makes Rittenhouse look guilty, first of all, we were talking about this earlier. That would be a Brady violation. It would be a very, very serious problem. It would probably result in a mistrial, maybe even a mistrial with prejudice, if that actually happened, if it was significant enough. A prosecutor who engaged in that kind of doctoring of evidence would be brought up on bar charges and almost certainly lose his law license. So his career would be over. Prosecutorial misconduct, civil charges would also be possible. Whether there would be criminal sanctions for it, that would require me to know more about Wisconsin law than I do. But it wouldn't surprise me, put it that way.
Awesome. Thank you so much.
I think we're going to start seeing a wave of support potentially for some sort of legislation, maybe to start tackling some district attorney misconduct. My general feeling is that a lot of people may be displeased with some of the stunts that Binger has pulled. I guess I'm not asking you to give him a grade or anything, but what's your opinion on his? I don't want to say behavior, but what's your opinion on Binger overall?
My opinion on Binger is that he's a small town lawyer who's trying very, very hard to be a celebrity and wants to be a bigger person than he is. I mean, apparently he ran for district attorney and lost in the Kenosha area. And he probably, I don't know if he volunteered for this or if somebody assigned him to it, but my impression is that he's enjoying himself a lot. The one thing I'll say about prosecutors behaving badly, and this is where, like, I always say that, like, the black guys are, like, spot on. It is absolutely true that cops and prosecutors frame people. I mean, usually what happens is there's, like, a dude in a neighborhood who the cops basically know is a problem. Maybe he's a drug kingpin, or maybe he's just some kind of a thug enforcer. But the guy is smart, and he knows how to kind of cover himself and not leave evidence. Okay. So then what will happen is the cop will maybe have a confrontation with him, rough him up a little bit, plant a gun on him, or plant some drugs on him. So when you hear about, like, criminal justice reform and that kind of stuff, and people say the cops frame people, I hate to break it to you, but there's a lot of truth to that. It happens. A lot of the cops are doing it for what they think are sort of noble reasons, because what they want to do is, like, kind of make their neighborhoods safe, and they don't have any other way to get a guy. But this is not that uncommon. And so one of the things that's funny is, like, when you get, like, the upper middle class white people, they see a case like the Kyle Rittenhouse case, they freak out and they think that, like, this never happens and it's only just this one time. It happens more often than people are comfortable admitting. And there's a lot of different motives and a lot of different reasons. But I'm just going to throw that out there. I said this last night too, and I'll just say it again very, very quickly. I am totally convinced that the Ted Bundy trial in 1979 was a frame-up. I know that he killed those girls, but I don't believe any of that evidence proved it. I don't believe that the woman who claimed that she did an eyewitness identification from, like, over 50 feet away when he was wearing a mask over his face could ever have positively identified him. The dental records, the bite marks on the girl that were introduced as evidence would never be admitted to court today. So what happened there is they had a guy who they knew was a serial murderer. They knew they had to get him off the street. They also knew they couldn't convict him with what they had. So they framed him. And, we could argue all night long about the morality of that. I mean, frankly, I think they had to do it because you got a guy, if they'd have let him out, more people would have died. But this is the kind of ugly reality of criminal justice that a lot of people think it's all clean and simple because they watch CSI or whatever, or Law and Order. It's a lot messier than that.
Thanks for letting me have the mic. Just real quick, I knew guys that were in and out of New York City jails for a long time, and you're very close. The cops do flake people. They call it flaking, not framing, at least in New York. But here's why streetwise guys go along with it. If the police knew everything they had done, they would get a 14-year sentence. But the cops give them a deal where they get off to, they got to go in for 18 months or something like that. And they'll plead to it. They'll sign whatever agreement. That way, all the other things that the cops don't know for sure that they did go away. So yes, people are framed, but a lot of these criminals, I don't know much about the Ted Bundy case, so I'm not going to speak about that, but most street criminals are arrested 15, 20, 30 times over and over and over again. So they all know the drill. Everybody knows the drill. The only reason why they plead to, they sign these plea agreements is because it's going to spare them a lot worse time for all the other stuff they did that the cops don't know about.
Yeah, man. I mean, I completely agree with that. I also really appreciate hearing that accent, which I haven't heard in some time. So I don't really have anything to add. I think that was a good contribution.
Yeah, he nailed the accent for sure. I haven't heard it. I'm a native New Yorker, 20 years removed. So nice hearing that.
Last question. Be great if you could settle this once and for all in my head. Not a lawyer, obviously, but is it voir dire? How do you pronounce it?
Voir dire.
So speaking of flaking or framing, that's a procedure that I've seen quite a few times in street justice. I mean, it kind of circles back around to what I was saying. And I know you disagree, and I am asking in good faith because I sort of disagree with you. I want to push back a little bit on the aspect of vigilantism because I don't see how what Kyle did isn't a form of vigilantism, whether we agree with it or we don't. I mean, anytime a police officer steps out of his
All right, look, I'm not trying to cut you off, but you're coming.
it's a form
On
of
my end, you're coming.
vigilantism.
Your sound is coming in and out.
I
Can you
also
stop for a second? Well, actually, you're coming in
looks
okay
like
now.
it's
So go
fixed
ahead.
now.
Go ahead. Yeah, go ahead and finish.
even though I mean it's almost like the Punisher story where you can't get something done the way that is the right way to do it, but you're doing the right thing. And
All right. I think he was having some technical problems. I didn't kick him or anything. Um, I'll just say this about vigilantism. I mean, my definition of being a vigilante is literally kind of being like Batman in Gotham and going around and attacking criminals because you know that there's problems on the streets or whatever. He brought up Bernie Getz earlier. Uh, I don't really even regard that as vigilantism. What you dealt with Bernie Getz was a guy who had some run-ins with people numerous times. He was a little dude. He couldn't really defend himself physically against much bigger dudes. 4 guys came up to him, surrounded him, and he shot him. Okay. And then you had a jury in New York who said, we're not going to convict this guy for the simple reason that we're sick and tired of the fact that we can't have a city where we can ride the fucking subway and be safe. It's very simple. And again, as I said before, he wasn't in the Bronx. He wasn't in Flatbush. He wasn't in Jamaica, Queens. He was in West Village. We all know West Village now is a super nice, like, upscale neighborhood with a lot of gays. Okay. It wasn't, in those days, it was an unsafe place in the subway. It's not now, or at least it wasn't until recently. So he was protecting himself. The Rittenhouse guy, I mean, literally, Kenosha, Wisconsin is not Gotham. It's not some crime hellhole. It's just a town. And he went up there to protect basically some car sources. And he had a gun, he got attacked, and he fired the gun. Now, to me, that's not vigilantism. That's just classic self-defense. But so that's all I'm going to say about that. I appreciate whatever that guy's was Shepherd Wolf or whatever his contribution was. That was fine. I don't really want to talk about the vigilante thing anymore.
Hey Fisher, so today somebody was arrested outside the courthouse with a "fuck Kyle" t-shirt on, and I was like wondering, like, does somebody like this like go into like witness protection or something? Like, what do they do to keep themselves safe after a trial like this?
You mean Rittenhouse?
Yes.
He's not going to go into any witness protection. I mean, he's not a witness. He's just a guy who got acquitted, and he may well be basically hounded for the rest of his life. I mean, I don't, who knows? I mean, in the current environment, it looks bad. What was the name of that guy who shot Michael Brown
in Florida?
Over in Ferguson, Missouri? I forget the name of that cop, but
George
he lost
Zimmerman.
his. No. That was another guy. That was the Florida guy. No, there was a guy. There was a police
Fisher?
officer. No, okay, yes.
Can I
Yeah, I
ask you
don't know his
something?
name, but yeah.
All right, I'm
The
going to
cop.
say this one.
Yeah, I
No,
know what
no,
you're talking about.
I'm going to say this
It
one
was
more
it was
time.
Darren Wilson.
No, all right.
Darren Wilson.
I'm not going to. If you're going to fucking interrupt me, I'm going to kick you. Okay? Let me finish what I'm saying. I'm not interrupting you guys. Okay? So yeah, there was a cop who shot Michael Brown who was attacking him. It was a really clear-cut case. There was a big thing that the media created a riot over. The Justice Department came in and they looked at it, and they basically said it was a justified shooting. And they interviewed everybody on the ground, most of whom were African American, and they determined it was a justified shooting. But we had to burn a whole city down anyway. Okay, that guy, nobody knows where that guy is because he has to live in a kind of a hiding. Now, I don't know if he still has to, but certainly for the first couple of years afterwards he did. And my suspicion is that this Rittenhouse guy, will probably have to take very good care of himself and be very careful for several years. I mean, eventually the memory will fade, but not immediately. Go ahead if somebody wants to
Darren
chit-chat.
Wilson.
Yeah, that's
I
right,
had
Darren
a
Wilson,
question.
yeah.
I had a question.
He is in hiding. The opposite, conversely, George Zimmerman handled it totally different and stayed in the public light. That's a weird contradiction.
Yeah, there's actually a really good piece in the New Yorker called "The Cop" about Darren Wilson that I'd recommend reading if you guys want to know more about like how he handled himself.
All right, if the people who are not chit-chatting and don't have anything more to say, why don't you exit, because there's a whole backlog of people, and I've really only got maybe 30 more minutes. So
I do
I
have
have
a
a question.
question. Can I say
was
something?
wondering.
yeah,
Holy shit!
I'm
all
sorry.
right,
I do
all
live in
right.
the USA. I'm from Argentina, but I would like to know when can you shoot in self-defense?
When you're defending yourself.
Oh, I mean, yes, I do know that, but they're all laughing. Okay, there's literally gun control in Argentina. I'm so sorry.
Oh, that's your fault.
Oh,
I have
come
Young
on.
lady,
All
I have a
right,
question. Can I
no
go?
need. All right. So I didn't have to do the whole hand up thing the other night because people were pretty responsible and respectful. But if people are going to just talk all over each other, I am going to do it and just start kicking people. Okay. So let's just if somebody comes in, just let them say what they're going to say. All right. Go ahead.
I have a question. I was wondering why nobody has pointed out the fact that the rebellion clause of the 14th Amendment protects Kyle Rittenhouse.
Yeah, I don't know about the rebellion clause of the Constitution and how that applies here. But to the young lady's question earlier, when can you use lethal force to defend yourself? It varies somewhat from state to state, but the reasonable man standard is that you believe you are in imminent danger of grievous bodily harm or death. So a small person against a much larger person, a woman against a man, multiple opponents with weapons. All of this is the sort of the legal grounds for you using lethal force.
James, that's what exactly I was talking about. I just wanted to know if it varies between states and stuff because it's not the same here. So thank you for answering instead of laughing.
All right, I have a question, a legal question. And Fisher, thank you for having this space and providing me a mic. So, like, when the prosecution was bringing up, like, Jump Kick Man and Yellow Pants Man, like, and they were putting that in part of their argument, are they able to do that because those people weren't called as witnesses?
They're able to do it because there was a video footage of the guy, and apparently nobody knows who it is. And so they had to have a name for him, and they didn't have a name. I mean, they just, they had video evidence that was admissible, and they were just using as a shorthand how to refer to a guy. It's not really, it's not really that complicated.
Okay, thank you.
Fisher, what do you think the guesstimation of the cost of a trial like this?
And thank you for having this, is if the jury comes back hung, does the judge then have the opportunity to go with the dismiss with prejudice?
Yes, he does. He has that
Yes,
option.
he does. He has that option.
Thank you.
Hi, this is
Hey,
Pam. I'm up in Montana, and I feel like this trial is kind of twofold. It's either trying to scare everybody away from carrying a weapon and defending themselves, but I don't think it in any way empowered people to defend themselves more. I think they tried, it literally tries to scare us, but I find that up here with the open carry, people are a lot more amenable, that's for sure. And I think that in a lot of ways it detours people probably trying to attack someone else. So I kind of see this as hopefully a positive in that defending yourself is okay.
Well, that's a statement that I mostly don't disagree with, so I don't really have anything to add. I mean, do you have a question, or is that you just want to make a statement?
I think my question is I think this young man was doing what he thought was right. Right? So how will, I guess, whoever be able to make this young man's life a little bit better for doing what was legally okay?
Well, as I said, I mean, if he's acquitted, that doesn't mean that people are going to leave him alone. He's gonna be talking about this for the rest of his life, and probably doing TV interviews 10, 15 years from now, because it was a big deal. That's kind of up to him. I mean, the one thing I'll say in his favor is that he kind of had the gumption and the wherewithal to go down there and take responsibility in his own hands to try to defend these car sources or whatever. My guess is that he'll have the wherewithal to structure his life in a way that's positive. I mean, beyond that, I can't, that's kind of his problem, not mine.
Yeah, I agree with you, Fish. Can you hear me? I've been having some issues. Can you hear me?
You kind of go in and out.
Oh,
I mean, I heard you just
okay.
now, but
So I don't think this case at all is going to be looked at as something prohibitive to self-defense or our, right to carry or our right to stand our ground. I mean, this is not a kid who was in his home or in the grocery store or defending, his classmates from a school shooter or something like that. It's a different standard of evidence in a case like this where there was an event going on where he felt compelled to be a part of it. He made a choice. We all make choices, but he made a choice. He put himself in that decision, whether honorable or people feel it's dishonorable. He made a choice. In a self-defense, a typical self-defense case, the choice is made for you by others' actions from the beginning. So I think there's a real different standard
Yeah, look,
here.
I just completely disagree with that. I mean, he went up to protect a riot situation, and people attacked him, and he had to defend himself, and that's kind of the end of the story. Look, I'm not being a dick or
They gonna
anything.
play with his booty
Hold on, stop it. I'm gonna move you into the listeners, Shepard, because I got a bunch of people talking, and you want to talk, and you've talked a bunch.